LeMoine versus Jackson, whenever you're ready.
Good morning, Your Honor. My name is MYRIELLE LEMOINE. We're here today on the matter of LeMoine v. Jackson. I am not an attorney. I'm appearing pro se, and I am on this case. I'm not sure if you'd like some procedural history in the case, or if you'd like for me to get started.
You can speak up just a little bit.
Okay,
Thank
sure. The reason we're here today is because there have been several judicial errors that have been made in my request for modification. The first one that I'd like to bring to the court's attention is the fact that the lower court decided that there was no finding of substantial change of circumstances in that case. That is actually the first most critical one. And what I'd like to do is bring your attention to Dobson v. Dobson. And in that case, it was a situation where the appellate court affirmed the lower court's ruling to modify primary custody of the children to the children's father. The children had failed the academic school year. Mom did not find a tutor for the children. Dad did. Mom missed parent-teacher conference that were necessary to initiate psychological testing for the children. There were some serious dental issues because Mom did not take the children to their scheduled checkups. When you put the similarities to my case, what we have is, even with a prescription from the pediatrician to initiate speech evaluation for our son, that canceled the evaluation. The end result of the speech eval was that our son had serious speech delay. Our son was born with a medical condition that required him to have ongoing observation. Dad decided to no-show for the, Dad actually was a no-show for the 3-year-old physical because he simply forgot. Dad canceled the 2-year-old physical at 11 o'clock in the evening because on the eve of the appointment. Dad made a unilateral decision to fire the pediatrician and left the child without a pediatrician because he simply did not like the pediatrician's notes in our son's file that favored me, Mom, as the primary custodial parent. When we look at this case and we find that the court found that there was sufficient evidence to support a change of circumstances, it is clear that the case law did not get applied to my case here. In addition to this, the court also gave Dad the sole authority to make all routine and essential medical appointments for his son. When you look at Kesey v. Kesey, which is a court ruling where Mom was given custody that was also affirmed by this court with the finding that the mother had greater insight into the children's feelings and emotional needs than the father. In all of the medical concerns that I have brought up to the court in reference to the concerns that I have about our son, they were validated. Dad testified that he did not detect any medical problem, any speech of the child. I testified that our son's use of nonverbal communication was of concern. That was validated by the speech therapist. The speech therapist also recommended speech therapy, and in addition, they also recommended psychological testing. Again, in this case, I showed to have greater insight and increased willingness to address our son's needs. I quote Dad in the records that he did not address some of the issues because he felt that my addressing them was to have legal leverage, which is just not in the best interest of our son. In Kesey v. Kesey, it is clear that the court felt that the parent best suited for primary custody is the one that actually has greater insight in reference to child's needs, which is also what I've proven to the court as well. In Strickland, which was a reversal by this court, the appellate court reversed the lower court's decision to switch custody to Dad because it was simply granted on the basis of Dad's marriage and work success. And what the court found in this ruling, was that there was no need to find that the prior custodial parent was unfit. But the court did state that negative factors in the circumstances of the custodial parent, coupled with intervening special needs of the child, and increased ability and willingness for the other parent to provide for the child may be sufficient for to justify a change. Again, this is right on with my case. I am not arguing that Dad is unfit. I'm arguing that our son has special needs, and I have proven to have an increased ability and willingness to address those needs. One of the things that the court looks at is in Kesey v. Kesey, the court wrote that no reasonable judge would have reached a conclusion being made a reversal is possible. In all three of the cases that I've presented to you, Dobson v. Dobson, Strickland v. Strickland, and also in Kesey, the lower court and the this court made a total reverse decision of what the decision was made by the lower court in my case. The other area that I want to make sure that
What's the standard of review that we need to apply on the issues that you raised?
there were errors that were made in the lower court's decision.
Do you understand that the standard of review that we have to apply is an abuse of discretion standard? In other words, if there are arguments on both sides so that this was a judgment call, then we have to defer to the trial court's judgment. Even if we might disagree with the trial court, we have to defer to the trial court's judgment. In other words, this is abuse of discretion.
Well, I believe that, yes, the trial court judgment, normally you would defer to them, of course. The trial court also has a lot of leeway in those types of cases to use their judgment, but what the trial court does not have is the leeway to deviate from the law. We have some case laws that are right on with the case that I'm presenting to you today that were not applied to my case, which they should have. The other area was that the court stated that I failed to establish any interference whatsoever. It is clear in doing some research that this factor itself today is no longer sufficient to warrant a change in custody. But there were several facts of my case. 1 week of vacation required court time, attorney fees, time off from work to attend the hearing, and our son is not even of school age. And parents, we live about less than 10 miles apart from each other. A Sunday overnight for Mother's Day, there was attorney involvement that brought the police to my house to retrieve our son because he had decided that he changed his mind about the overnight. The therapist testified that our son hit both parents, that she witnessed him try to attempt to bite me at least 3 times. She recommended behavioral therapy. That claimed that he did not have any problem with me taking our son to the behavioral therapist to deal with our issues, but he did disallow the appointment.
Did you argue to the trial court that the father denied time that was court-ordered with the child, or was it strictly related to situations where you were asking for additional time and arguing about whether you were entitled to additional time?
No, Your Honor. The father, and as I go here, you will see, did deny time that was court-ordered. When the original order was issued, it was issued under the premise that I was in Massachusetts attending law school. Immediately upon the judge's pronunciation, I said, I will stay here. I will not go back to Florida, to Massachusetts to continue law school. The judge said, I do not have any evidence of that, but let's go ahead and do a standard visitation. You can put in for a modification once I see proof that you're actually here. And one night a week, one Sunday, basically the standard overnight visitation. December comes, and I was exercising those visitations. December comes, the final order was issued under the premise, the assumption by the court that I was in Massachusetts. Although I
had you filed something with the court to prove that you were still in Florida? What did you file with the court to prove that?
I had filed motions for reconsiderations. I put in there an affidavit statement.
Had the order been modified?
The order had not yet been modified.
Okay. And as I understand your complaint, it's that your husband insisted on following the order that had not been modified. Is that correct?
The order had not even been written at the time. He had just received the order. Prior to that...
How had he received it if it had not been written?
I'm sorry. The day that he received the order, it stated that I was in Massachusetts attending law school. Yes.
Okay.
But prior to this, at the hearing, the judge said, yes, if you are going to be here, let's go ahead and put this visitation in motion.
But it wasn't in the order? It
was not in that order.
And your complaint was that your husband followed the written order, which you believe inaccurately reflected the circumstances, correct?
Well, he took advantage of the written order.
Well, he followed it, correct?
I guess we could state that he did not follow it, yes.
So other than following that order, did you claim that he violated any provision of a court order with respect to visitation?
I think the bigger
my notes reflected at page 273 of the transcript, you admitted that your former husband had never, except for with respect to one funeral, with permission, violated a visitation order.
And I think in most of the issues in reference to this, and primarily because in this case we do not have a court order that was signed up until later, although I was exercising the visitations that my attorneys were able to give me, if that's the legal verbiage, then the answer is no, you are.
Okay.
Okay. The other area is when we look at the issues of dealing with frustrations of the visitations and contact. In Williams v. Williams, it goes on about that. But what's also interesting to this case, in spite of your statement that I'd like to reiterate, is that the court supported the change of custody primarily because they also saw that there were factors there of unusual behavior in reference to the child. It's the same thing here. Our son's behavior was so alarming that the doctors said, hey, let's get him into behavioral therapy. Let's go ahead and get him some psychological care. Dad, again, refused. The other area is, in spite of the way that Dad handled medical issues, Dad was given primary responsibility, actually all responsibility, to handle all routine and essential medical appointments for his son. Basically what that means is that in spite of the way he handles it, I am forbidden from making any of his appointments. Now, the closest that I was able to find a case is Chris versus Dominican, which is not really in this court. It's in the 3rd District. However, when you use that case, what you find is that it is surrounding the fact that mom had made some very unilateral decisions in reference to the child's care. In my case,
doesn't the case law say that the trial judge has the discretion to grant exclusive authority to one parent over medical decisions when there's a continuing dispute between the two parents?
That's correct.
It wasn't, I mean, there was clearly a dispute between the two parents.
There was clearly a dispute between the two parents, but it seems to me in this case that the trial court may have made a decision based on, okay, if Dad has primary, so let's go ahead and give Dad that primary responsibility, which is, quite frankly, in Cruz, Mom continued to have primary, but because she was making those unilateral decisions, Dad was the one granted those decisions. So Dad has primary, Dad makes all those decisions, but I don't see where it's in the best interest of our son that in addition to this, that Dad would also have those increased responsibilities on something so crucial to our son.
In this case, the canceled appointments that you complain about and the, I guess, canceling out a pediatrician in its entirety or not going to that pediatrician anymore that you complain about, were those things that were set up originally jointly or unilaterally? I mean, did he not come to an appointment that you all had jointly scheduled, or was it an appointment that you had unilaterally scheduled?
With the 2-year-old physical,
Yeah.
Dad had scheduled that. Or I should say...
Was that with Dr. Ahmed?
Yes. So I can't say that Dad had scheduled that because the doctors generally, when you go, they would say the 2-year-old physical is coming up until the 4th. So Dad would have had ample time, even if the doctor had just said, hey, let's go ahead and put this on before the eve of the appointment, at least 2 to 3 weeks prior, to be able to say, hey, I'm not happy with them. Why don't we look at somebody else? But instead, he, the night before, canceled and went on.
Was that doctor jointly selected originally, or how did that doctor become the child's pediatrician?
The doctor became the child's pediatrician. I have another son who's now 14 years old, and he was my older son's pediatrician. So Dad and I were not together. Actually, the breakup took place while I was pregnant. So during the selection of doctors, I had informed Dad, hey, Dr. Ahmad has been providing for the care of my older son. And basically, we went to the first appointment with Dr. Ahmad. Dr. Ahmad was there for the circumcision, so the introduction was there. Dad had never expressed any concerns about Dr. Ahmad whatsoever.
I am having a hard time understanding how a decision to change pediatricians constitutes a substantial change in circumstances to justify modification of...
No, Your Honor. I'm not suggesting that a decision to switch substantial change of pediatrician is a substantial change of circumstances. When you look at this case as its whole, there's plenty of substantial change of circumstances. When you look at the fact that Dad did not whatsoever make have any interest in resolving those issues or seeking help for a son, and you apply that with the fact that it doesn't.
As I reviewed the record, it appears that your ex-husband canceled that appointment, but then made an appointment with a new pediatrician who did not initially diagnose any kind of hearing loss or problem with respect to that. But once it was diagnosed, it looks like your husband was very diligent in making sure that it was addressed. Is that inaccurate?
That is inaccurate. because what happened was when the doctor gave the prescription, I had expressed concern with the new pediatrician and said, hey, these are my concerns. She said, go to Easter Seals. You definitely need to look into this. Then we went ahead and had an appointment scheduled with a speech therapist. Dad decided that he did not want to proceed with the appointment. Okay, the speech therapist, the lady who owns the speech therapy company, had to stay on the line with Dad, convince him, hey, this is important. If you don't take care of it now, there's going to be some serious issues later on. Okay, that's the level of extent that it took. Same with the ENT specialist. Everyone would know that if your speech is affected, if your hearing is affected, your speech is going to be affected. They work hand in hand. Dad again refused. And if you look at the record, I think there's direct statement from Dad stating, hey, I did not want to give Mom any type of legal leverage. And that certainly shows how Dad just does not have our son's best interest in mind.
You're down to about 4 minutes if you want to save any of it for rebuttal.
I definitely would like to do that.
Okay.
Thank you.
Good morning, Your Honors. May it please the Court. Let me, if I may, this was not a marriage. This was a fraternity action.
I'm sorry, you're right.
And just to kind of correct the perception. If it's okay with y'all, I'd like to refer to the parties as Mom and Dad because it's just easier for me to do that. I'm going to spend very little time on Mom's case in chief. And the reason that I'm going to spend very little time on the Mom's case in chief is because the law is very clear. Just as you stated, Judge Lawson, the standard of review is an abuse of discretion. And the judge, meaning Judge Mize, made his decision based on the evidence that was presented to him at the trial, which is in the record. One of the problems that I have had with this case with the pro se litigant on the other side is there are times that our pro se litigant sometimes refers to things that she believes is in the record, but is not necessarily in the record. So I would ask the Court, if you all would be so kind, is to stick to the written record that we have before the Court and nothing more. Judge, or Your Honors, there was no real evidence at the trial that this child was a particularly sickly or special needs child. It is a child who goes to the doctor from time to time and has problems from time to time. Judge Mize did not abuse his discretion. Judge Mize evidently determined that the best way to resolve the conflict between the parties at doctors' offices was to give Dad the authority to make those decisions. And just as you had referred to, Your Honor, when a court notices that there is that kind of conflict, sometimes the judge has to just say, well, in order to stop the conflict, I'm going to give one parent's sole custody as it relates to medical decisions, and that's what Judge Mize did. So for those reasons, we believe that Judge Mize heard the case, made a determination that the standard of proof, meaning that there has been no change of circumstances.
What were the alleged substantial change of circumstances? What was the basis of the petition, and what did Judge Mize rule in regard to that?
Judge, I believe, because this case, if you will look at the index, you will see that this case has been going on and on and on since Judge McIntosh first determined custody and visitation in 2003. But as best that I can put my finger on it, it was, number one, you have denied me access or a relationship with my child, and because you've done that, you have demonstrated that I should have primary residential responsibility. That's boiling down part of it in a nutshell. And the other part to boil down in a nutshell is our child has medical problems, and you are not addressing those medical problems properly.
What about the issue of the original order was entered on the premise that Mom was going to be in Massachusetts going to law school, and now she's back in Florida? Was that modification granted? Or
Your
was
Honor-
that not even found to be a substantial change?
Your Honor, to be blunt with you, that's one of the problems that I have, because that's not in the record before the court. The record before the court is the trial record before the court. And Mom has determined to argue matters that were in front of Judge McIntosh 4 years ago.
So the petition for modification didn't allege there's a substantial change of circumstances because the order is premised on me being in Massachusetts and I'm now in Florida? That wasn't part of the petition?
A motion for rehearing was premised on that. Right off the top of my head.
Which was or was not granted?
It was denied.
Okay. So the order that was in place was a parent in Massachusetts, parent in Florida kind of a visitation?
No, sir. The order that was in place was both parents are in Florida with a traditional visitation schedule. Because I don't want to go beyond the record, and frankly, I feel real uncomfortable about that. But
the contact order that's in place is a standard kind of contact order when both parents are local?
yes, sir. It's and it was a traditional visitation order. And if I go beyond that, Judge, I'm going beyond the record.
I appreciate it.
And that's what it was. And
So the focus of the arguments about change of circumstances is how the parents were dealing with the doctors and with the child and the behavior of the child.
yes, sir. No, it was that, and that, Dad, you have interfered with my relationship with the child. And if you look at the transcript, you'll notice that, and you'll look at the transcript, you'll notice, Judge Lawson, as you noticed, the testimony from Mom was, no, Dad has never denied me court-ordered visitation except for one time he went to his brother's funeral. But to go beyond that, there is also evidence in the transcript that not only that, but there have been times that Mom had asked for additional time, that Dad had said, okay. And there had been times that Dad said, I'm going to be out of town, would you like son? And Mom said, okay. And the gripe really is, for lack of a better way of putting it, you don't give me additional time every time I ask for it. And that is not denying a relationship with the child. I mean, that's the long and the short of it. The issues that I would like to address, however, and these are the ones that are most important to us and, if you will, most near and dear to our hearts, are the issue of the dissolving of the injunction that Judge Mize did and the issue of the denial of attorney's fees for the father. And if I may, let me address the issue of the dissolving the injunction first.
Is our standard of review on both of those also abuse of discretion?
I am not sure, Judge, and the reason that I say that is this. I have, and maybe I'm wrong about this, but I did research and I could not find a case where the appellant was saying you dissolved an injunction without proper evidence. All of the cases said you should have, or all of the appellants were coming in saying you should have extended this injunction. Do you understand the distinction?
Well, but in any event, isn't it clear that the trial court has discretion in making those decisions?
Certainly.
Discretion whether to award attorney's fees, discretion whether to keep an injunction in place. And as long as the trial court has discretion, inherently our standard of review becomes abuse of that discretion.
Certainly, and I can't argue with that. But our point was this. There needs to be, and perhaps maybe you all need to speak to this, but there needs to be some sort of guidance about what is the burden, what is the standard, what do you have to prove when you come into a circuit court and say, Judge, we want to dissolve an injunction. Because all of the cases that I read dealt with, Judge, we want to extend the injunction. But the problem was, in our case here, the issue was, Your Honor, we want to dissolve the injunction. And it's our position that if you want to dissolve an injunction, you got to show that there's some sort of substantial material change. And there wasn't that shown in the court record. In fact, the showing
Well,
was...
wouldn't the basis be that there's no longer a need for the injunction? An injunction is to avoid irreparable harm, and if the harm isn't there anymore, wouldn't that be the basis on which you could say?
Certainly it would, but you have to at least show that. And with all due respect, I'm not trying to be sarcastic about it, nobody showed that. There was no evidence before the court that the injunction was no longer needed. There was no evidence before the court that the dad was no longer in fear. It just wasn't presented. And it's not the dad's burden, frankly, to present that evidence.
So Dad didn't present evidence that he was still in fear, but it's your position he doesn't need to. Mom's got to present evidence that there's no longer a reasonable basis.
Exactly, Your Honor, and to make it more basic than that, it's our position that the moving party has to support their case. The defending party doesn't have to do anything until the moving party establishes a prima facie.
What was the factual basis on which the injunction was issued in the first place?
Judge, if I get into that, I'll be going beyond the record, and I don't want...
Is there a record to support the injunction? But it's not part of the appellate record?
No, sir, it's not. It was there was a, and I can explain this because it is part of the record. There was a paternity action that was filed and an injunction action that was filed. The two actions were consolidated according to the administrative rule of Seminole County, and it went on from there. There are allegations in the injunction file, but that was not in the record before the court. And I was there, but it would not be...
What was the evidence, if any, or argument presented in support of the motion to dissolve the injunction?
Okay. There was, in my opinion, no competent evidence presented at all. We believe that we presented evidence that Mom had continued to do violent things by stalking. If you may recall in our brief, we talked about how Mom had gone to Dad's fiance's place of work, checked out her car, and that is in the court record. And that was evidence that we presented to the court. And we believe that...
And it was your position that that constituted stalking?
Yes, sir.
And what all had she done that you say constituted stalking?
What we said that she did, and this is in the court record, is that Mom went to Dad's fiance's place of employment, which was a bank, walked into the bank, checked out where what fiance looked like, what she did at the bank, represented to the bank officer that she wanted to open a bank account at this particular bank. Right off the top of my head, I believe it was SunTrust in Altamont Springs, right beside the Altamont Mall, but don't hold me to that. She then, according to the testimony, walked outside, checked out fiance's car, checked out the license plate, and drove off. We consider that stalking just by definition in the statute.
What's the definition in the statute?
The definition in the statute, may I?
Sure.
Any person who willfully, maliciously, and repeatedly follows, harasses, or cyberstalks another person. Does that sound about right?
Yes.
So there's a repeatedness element required. And what's the repeatedness here? What she did in the bank and what she did in the parking lot?
Yes, sir.
It has to be repeated, right? The statute is and repeatedly. So
Yes.
given that, it's got to be, that's one of the requirements.
Yes, sir.
So when did the stalking come into being?
During the pendency of the case.
No, I mean in the factual events. When she walked into the bank the first time and what she did inside the bank, would that constitute stalking? And if so, how was that repetitive conduct? And if not, when did the repetitive conduct occur which turned it into stalking?
If the statute is read that it requires repetitive conduct, which I think is a reasonable reading, and I think that if the court says that the coming to the bank, walking through the bank, checking out the car is all one single transaction, then it'd be disingenuous to me to say that that was stalking.
And if you didn't have that stalking, is it your position that the injunction still should not have been resolved?
Yes, sir. And
Because the burden is on mom to prove something, and she
the
didn't.
burden is on the moving party to prove their case. It's not on the defending party to defend their case. That's our position. To me, it's a pretty simple position. It's the state of the law in all cases, whether it's a civil case or a criminal case or any motion
Does the
whatsoever.
record describe who Yolanda Lewis was?
Yolanda Lewis, if my memory, Yolanda Lewis,
Isn't that the person in whose favor the injunction was brought or entered?
Yolanda Lewis was a former girlfriend
Right.
of Mr.
She's no
Hill.
longer in the picture at all.
No, sir, she's gone.
And if there's an injunction to protect somebody who's no longer in the picture, and there's evidence presented that that person is no longer in the picture, and why isn't that enough to dissolve the injunction?
Because there is also an injunction in favor of Kevin Jackson for protection against violence, as well.
And that's the injunction that was dissolved with your complaint.
Yes, sir.
You don't have standing to argue about the other injunction.
Frankly, we
It was
don't
one
care about
injunction,
the
wasn't it a single injunction that protected Yolanda Lewis and husband?
boyfriend, but
Boyfriend.
yes, that's okay.
Why would the trial court include in the judgment then that Ms. Lemone had introduced substantial evidence to justify dismissal of the injunction for protection, and it gives the case number? Was that just an invention that the trial court came up with?
No, sir, it wasn't.
What would the trial
And
court
frankly, I don't know, because procedurally what happened at the trial was this. Ms. Lemoine put her case on. We put on one witness that was the bank president because he had to go back to work. At the conclusion of Ms. Lemoine's evidence, we moved for a dismissal based on the argument that you haven't reached the burden of proof. Judge Mize at that point in time made a decision on everything. And he probably, what he should have done is if he was going to make a decision based on the evidence before the court at that point in time, he should have probably said,
So
well,
according to you, what you're telling me, I think, is that either he put this in by mistake or he just made it up?
no, sir, I'm not saying that. I believe, and I would not say that about Judge Mize, frankly. But I believe that the judge was incorrect.
Okay. Put it in by mistake?
No, sir, I believe he was incorrect.
Mm.
And I don't believe that he made it up.
All right.
And so I'm not saying that he made a mistake. I'm not saying he put it in by mistake. I'm saying he was incorrect. I'm not saying that he made it up. I'm saying that he was incorrect. Last, Your Honor, we believe that the court erred by failing to award attorney's fees in favor of Dad in this case. And we believe that if the court will simply look at the index on appeal and look at the volumes and volumes and volumes of stuff that was frivolously filed by Mom from the date of the first trial in September of 2003 through 2004, 2005, 2006, and up to today, the court would agree, I think that y'all should agree that the litigation that was brought before the court was frivolous.
What's the basis on which you claim attorney's fees?
We were asking the court at the lower court for attorney's fees based on Rosen and the fact that this was frivolous litigation.
Didn't the trial court say that it wasn't frivolous?
The trial court said that there were some issues that needed to be determined by the court. and particularly the trial court referred to the visitation issue and I believe the injunction issue. And I believe that as a practical matter, the visitation issues should have been resolved at mediation, and they could have been. And I believe, and
Well, that's certainly no standard to award frivolous attorney's fees, right? That you could have resolved it in mediation and you didn't do it.
well, I understand that, but if you look at the temporary order for visitation that was in effect, it's probably in the court file. There's not a whole lot of difference between what Judge Mize did and the temporary order that was still in effect. So all of this litigation, basically the only benefit that Mom got from it, with all due respect.
But that's not the test either.
I understand.
I mean, we're not talking about prevailing party
I
attorneys.
understand. Well, although sometimes perhaps maybe we should, but the benefit that Mom got from it was to have the injunction dissolved. Everything else went to Dad. And everything else stayed virtually the same as it was from Judge McIntosh's September
Do you
2000.
mind if I go back to my prior question, because I'm a little bit concerned. A bench trial was conducted in August of 2003, is that correct?
Yes, sir. Judge, I'm about
And we don't have a complete transcript of that trial, although we have portions of it, is that right?
I don't think we have any transcript to speak of except for perhaps.
Well, we have the court's ruling.
Yes, sir.
Part of the transcript that
Right.
contains the court's ruling.
Yes, sir.
And then we have a final judgment or judgment that indicates that the trial court was satisfied that sufficient evidence, substantial evidence was introduced to justify dismissal of the injunction for protection. We have that finding in the final judgment.
You do. I'd be lying to you if I said
Okay,
you didn't.
but we don't have a transcript of the hearing. So what do we do with that finding other than say it's presumed correct?
I understand that position. Our position is that it is not our burden to prove that. It's their position.
So I know, but we have a final judgment that says that the opposing side has introduced substantial evidence to justify dismissal of the injunction for protection, and it references the case number. And we know that a trial was conducted in August of 2003, but we don't have a transcript of that trial. So we have to presume that the trial court was correct when it made that statement. And we can't say otherwise because we don't have the transcript of the trial proceedings to determine what was testified to and what wasn't.
I don't think that you could, even if that transcript was in the court file, I don't think that you could refer to that because I think that would be beyond the record of the trial court of the trial itself.
Well, I thought your complaint is that there was nothing introduced that would justify dismissal of the injunction. Did I misunderstand that?
No, sir, you did not.
All right. And we have a finding, and I won't repeat what the finding says, but the trial court was satisfied that substantial evidence was introduced to justify dismissal. And we don't have the transcript. How can you say that looking at the transcript would be improper for us to do when the testimony as to that would be included in the transcript?
Your Honor, you do have the transcript of the testimony that was presented to the court in order to dissolve the injunction.
Okay, and that's in the record.
Yes, sir. That's the
So
trial.
that part of the transcript is in the record.
Yes, sir. All of that was brought before Judge Mize.
Well, I thought that you just told me that maybe I misunderstood, but the only part of the transcript that's contained in this record are the findings of the trial court.
I misunderstood you.
Okay,
I
so
misunderstood
it's
you
there.
because I was thinking that you were asking about the original order from Judge
Okay,
Mize.
I must have misunderstood.
Certainly on your cross appeal on attorney's fees, if the action is frivolous, which you have the burden on because it's the cross appeal,
Sure.
the lack of an entire transcript hinders our ability to say it's frivolous, doesn't it? Because we don't know what was said during those parts of the transcript
No, sir.
that might have showed it was non-frivolous.
No, you have the entire trial transcript. You don't have the transcript for the original injunction that was entered in 2003, but you do have the entire trial transcript of what went on the 2 days of trial in this case. You do have that.
Okay, we have that. All right.
Yes,
Okay, I misunderstood.
You're well over on your time.
And I apologize.
All right.
Thanks.
Thank you again, Your Honor. Your Honor, on the substantial change of circumstances in addition to the medical issues, going back to Judge McIntosh's rulings, and Mr. Colbert brought that up, the key major reason why Judge McIntosh decided that she would give custody to Dad was because she felt that I had, quote-unquote, so much hatred for Dad's girlfriend, Yolanda Lewis. By the time we reached trial, she was out of the picture. That was one major key factor that Judge McIntosh looked at. Her belief was that I had not allowed overnight of our 12-month-old son because she was there. By the time of trial, she was nowhere near there. My move here was also something that I put in my modification. And actually, in Judge McIntosh's modification, she did make reference to the fact that if I were to move here, that there would be the possibility of a modification. Okay. And looking at the medical issues and applying the case laws that were utilized in those same factors, it is clear that there was substantial change of circumstances that were provided. So I urge the court to look at that. In reference to the misuse of injunction, if the burden of proof is upon me, I think where the court came about with saying that I provided substantial change of substantial evidence with that is that whenever there were disputes in reference to the medical care, Dad would call the police and say, hey, I have an injunction. I'd like to have her removed from this doctor's appointment. There's also evidence in the record that I asked Dad for a copy of our son's medical insurance card. He denied giving it to me. I called our son's insurance provider. Dad sent me an email saying, hey, I have an injunction against you. Don't call my insurance provider, when I was calling in reference to our son. In reference to attorney's fees, quite frankly, I would not be here if representing myself if I had the legal, the financial means that Dad has to have legal representation. But going back to the fact that Judge Mize himself made notion in his finding that he saw that my actions and petition were not frivolous because there were genuine issues in reference to our son's health care and visitation. You know, if he makes that statement that there were genuine issues in reference to our son's health care and visitation, hopefully collaging the case laws that I've talked about to the facts of my case will show that those issues were significant enough for there to have any change of circumstances. Significant enough to have a change of custody. Any questions?
Thank you both.
Thank you.
Very well argued. Court will be in recess.